We will go on the record in the matters 25 CM 212, 25 TR 660, State of Wisconsin versus Byron Benjamin. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, Defense Counsel in person, along with Mr. Benjamin. We were set here for a plea and sentencing. Mr. Benjamin or Mr. Chapman, is this matter proceeding as such today?
No, it's not, Your Honor. And I have 212. What was that other case number you said?
25 TR 660.
Oh, okay. TR, that's fine. Unfortunately, I haven't been able to reach Mr. Benjamin for a while, and he just walked in 3 minutes ago. I do not have the paperwork ready, and we haven't talked, so I would ask that it be reset for another plea and sentencing, please.
All right, I can.
He is here.
He's right here. I can do that. Mr. Benjamin, a couple things before I set a new date and time. Are you still on Udina Street?
Yes.
And telephone ends in 0994?
Yes.
May we send you text messages?
Yeah.
All right, and you have not been making your monthly payments. You are 2 months behind, I think.
No, and the attorney.
Wait, are you 2 months behind?
Or-
Yeah, or you haven't paid anything since you're, so February, March, April, yeah, 3 months behind, but yes, for your attorney fee,
Where do I?
go to the clerk's office right
Just-
up front, and then you can just become current. Mr. Chapman, let's get a new date and time.
Can I ask something?
Yes,
Can I come pay that in like a few weeks? I'm broke right now. I'm also paying for a monitor, alcohol monitor
oh,
in Pine County.
you're saving for that?
Money's kind of tight right now. I get off it like next week, hopefully.
Or you're not on it yet?
No,
right now?
I've been on it for like the past 8 months.
For probation?
And Pine County.
Okay. All right, let's get a new date and time, and then we'll figure out when to have that paid by, okay?
Okay.
Mr. Chapman, I can do May 28th. You have your pick from 9:30 to noon.
I have a 10:45 in Dunn County, which kind of wrecks that. Oh, I'm sorry, that's the 29th. The 28th, I'm in trial.
I have June 11th at 11:30.
That would be fine.
All right, so Mr. Benjamin, I am fine with giving you a little bit of time to get caught up, but
I need to get on top of it.
what?
Need to get on top of it.
I'm sorry.
Need to get on top of it.
Yes, you need to get on top of it. Let's see, can you have $200 paid? I can give you a month to pay $200 by the 15th.
Yes.
You'll still be behind, but at least you'll be more caught up,
Yeah.
okay? All
Thank you.
right, and then go from there. And so when do you get off of this monitor?
No, I got court April 21st, and my PO said I'll probably get off it then.
How much do you have to pay a month for that? Or a day?
150 every 2 weeks.
150 every 2 weeks? Oh, that's steep.
Yeah, so that runs me dry, especially not
That's-
having a job right now.
For like a ankle monitor?
No, that's a little thing you blow in.
Okay, it seems excessive to me.
Yeah, it is.
Ours are only, well, ours are $25 a day, so.
But
Yes, that
that's
makes
with
sense.
Huber fees, isn't it?
Yes.
Okay.
Oh, yeah, for just the monitor, I'm not sure how much that would be.
Well, Judge, if this case actually moves forward with a plea as expected, my bill is going to be like less than $250. So
I figured yours would be pretty low, so that's why I'm not pushing for the whole every payment. All right, so we'll see you then in June. Come and get your notice and you're free to go. I don't see Mr. Belisle.
Oh.
Leon Chapman,
Mr. Benjamin, I'll test it again, okay? Do you have a, yeah, she's got an envelope right there.
It's got her phone number at the bottom.
Thank you. You too.
you too.
Byron Benjamin appeared for a plea and sentencing hearing, but the proceedings were delayed because he arrived just minutes before the start, leaving his attorney, Daniel Chapman, unprepared. The conversation quickly shifted to Benjamin's financial struggles. He is several months behind on court-ordered payments. He explained that he is currently unemployed and paying $150 every 2 weeks for a breathalyzer alcohol monitor, which he described as a significant financial burden. The judge expressed sympathy, calling the monitor fees excessive, and granted him an extension to pay a $200 catch-up fee. The case was rescheduled for June 11th.
We'll go on the record in the matter 25 CF 35, State of Wisconsin versus Leon Chapman. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, Defense Counsel in person, along with Mr. Leon Chapman. We're set today in this matter for an initial appearance. Mr. Chapman, this is a newly appointed case, but were you able to go over the criminal complaint with Mr. Chapman?
I was, Your Honor.
He understands the charge and the maximum penalty,
He does.
formal reading or waive.
We will waive reading of the complaint.
Are you still at PO Box 103?
Yes.
That's where your mail can go.
Yep.
Telephone ends in 1855.
No.
How about 9839?
Yep. Correct.
So the other one can be removed.
Yes.
May we send you text message notifications?
Yes.
All right, this is a felony. He's entitled to a preliminary hearing. Is he requesting it within time limits?
No, in fact, we're prepared to waive the preliminary hearing outright today.
Excellent. So, Mr. Chapman, your attorney went over with you what it is to have a preliminary hearing? Yes?
Yep.
And you understand that the burden is on the state to prove a felony was probably committed by you?
Yes.
You understand that at a preliminary hearing, your attorney would be able to ask questions of the state's witnesses, would be able to call witnesses to testify for you. You'd be able to testify if you wish. Your attorney would be able to produce evidence on your behalf or possibly discover things about the case, which could include defenses. But for this hearing only, you'd be giving up those rights. Do you understand that?
Yes.
Do you understand that if the state does not meet its burden as to that felony, that means the court could amend it to a misdemeanor or dismiss it altogether, but you would be giving up that right for today's purposes?
Yes.
Do you understand that once you give up the right, it's forever and you cannot get it back?
Yes.
Has anyone made any threats or any promises to you for you to waive your right to a preliminary hearing?
No.
You're doing so freely and intelligently and voluntarily?
Yes.
I'll find that you're freely, intelligently, and voluntarily waiving your right to a preliminary hearing and find you competent to do so. I find probable cause and bind the matter over.
And I would ask that it just be scheduled for an arraignment.
Okay, sounds good. I'm not sure if you've had any discussions with him about the IDIP program. or
I have
anything
not,
like
but I
that.
will.
And you can get a brochure from Mr. Yeah.
Thank you. Absolutely. We'll talk about that more later.
All right, arraignment, April 21st at 9:30. All
I
right,
think that would be fine.
okay, you can come get your notice then, and then you are free to leave. Thank you.
Leon Chapman appeared for an initial hearing regarding a newly filed felony charge. During the session, he chose to waive his right to a preliminary hearing, a move that allows the case to proceed directly to arraignment without the state having to present immediate evidence of probable cause. The judge spent considerable time ensuring Leon understood the rights he was surrendering by doing so. Additionally, there was a discussion regarding his eligibility for a public defender. Despite being unemployed, his ownership of a newer vehicle initially disqualified him. The judge scheduled his formal arraignment for April 21st.
How do you have to drive to get here?
Mr. Morales?
Yeah, about,
You can come on up.
20 minutes or more like 2 hours?
no, it's only like maybe 10 minutes.
Okay, great. So you can be here in
And that,
person for that, no problem.
Then basically right at the stoplights in Siren.
Okay, just wanted to make sure if you were coming an hour for this hearing, I was going to ask if you could appear by Zoom. because it's just gonna be a quick hearing.
Yeah,
but-
it'll be very quick.
Okay.
And I'll give you a call later and we'll talk about what's in that brochure.
Mr. Morales, are you still laid off? You could apply for a public defender if you wish to do so. You did put money down because you had applied for a court appointed originally. Mr. Chapman,
I would take it if it was a public defender, yes.
he could, and he would take it if it's a public defender. So if you want to reapply with the public defender's office, you could do so. And I mean, that essentially would save you money on lawyer's fees.
I did try to do that already, and they said due to my vehicle, I can't qualify for it because I have a new vehicle.
But do you have a lot of equity in the vehicle? They
It,
go
it
by-
doesn't matter. Because he's
Yeah.
making a payment to the vehicle and they say that payment could be applied to an attorney if he wanted to.
Okay. Sometimes
Yeah,
I just don't.
Even though I owe quite a bit on the vehicle still.
Okay, that makes sense. So, okay. All right, so we'll go on the record in the matter 26 CM 32, 26 TR 04, 26 TR 19, State of Wisconsin versus Antonio Morales. The state appears through Assistant District Attorney Jose Vila in person. We have Daniel Chapman, newly appointed attorney, in person with Mr. Morales. We're set here today in these matters for initial appearance or for status conferences. Mr. Chapman, were you able to talk to Mr. Morales about these cases? I know you probably don't have an update, but maybe you have some update.
Actually, I've got all of the discovery and I filed a motion to suppress evidence last night that I'm going to be asking for a motion hearing on.
Oh, I have not looked at my inbox yet. It's been a crazy morning. All right, I see it right now.
Just challenging probable cause to arrest.
Yep, I see that, pretty straightforward. Okay. Well, I'm not sure if an officer would be available, but if they are, and you were planning on being here in person on April 21st, we could do it then, but that's a pretty quick turnaround for an officer.
Yeah, that's awfully quick.
I could. I could do April 28th at 11:30.
I'm in Pierce at 1:30.
At 9.
That would work.
All right, April 28th
that
at
work for you?
9.
Yes, it does.
I'm not sure. I didn't look to see who the officer was.
Officer Carroll or
Officer
Deputy
Carroll.
Carroll.
Yes, okay. That should work. Okay, all right, so you can come get your notice and you're free to go. Okay, Mr. Morales?
All right, thank you, Your Honor.
Oh, wait, motion for dismissal.
That was filed this morning.
Okay, okay. Did you let him know that?
The victim was here and the victim's his mother. So I would imagine one led to the other.
All right, sounds good. Mr. Hess?
Antonio Morales faced a status conference involving multiple traffic and criminal charges. His defense attorney, Daniel Chapman, filed a motion to suppress evidence, specifically challenging whether the police had sufficient probable cause to make the initial arrest. A notable detail mentioned during the hearing was that the victim in this case is the defendant's own mother. The judge acknowledged the motion and scheduled a specific evidentiary hearing for April 28th, noting that the arresting officer would need to testify. The hearing concluded with a discussion about the defendant's proximity to the court, ensuring he could appear in person.
We will go on the record in the matter 25 CF 160, State of Wisconsin versus Robert Teskey. The state appears through Assistant District Attorney Jose Vila in person. Mr. Teskey appears in person with his counsel, Joe Polisky. We're set here today in this matter for a status conference. A suppression motion was filed. The District Attorney's Office filed a response. The court did do an order denying an evidentiary hearing. I'm going to tell you on the record, I did it very quickly. There was an error in my order where I said the criminal complaint. It is in the criminal complaint, but I meant to say that the defendant stipulated that or stated those facts in the motion. But anyway, denying the evidentiary hearing. So here we are here today. Mr. Felisky, any update for the court?
Thank you, Your Honor. I have discussed this matter with Mr. Teskey, and at this time, we will be requesting a trial date.
All right, do we have the testing back and have a lab analyst?
Let me check for you quickly, Your Honor.
Alibi witness or third party issue you're gonna need to.
Potentially witness, I suppose. There may be other acts that we will be looking into prior to the trial date.
Okay, I'm just getting to know that so I can know how far.
Oh, of course. We did get the report back. Looks like it was done by the Wausau Crime Lab.
Do you have analyst?
I do. Her name is Michelle Fechelm, Fechelm as in Mary.
And you have, is it a
I have a DFS number.
DFS number? DFS, what is the number?
It's a CL 25-07220.
All right. We are off record for scheduling. First, let me get an idea. One day?
Yeah, one day. Unless Attorney Felisky feels like we need more. I think one day would be appropriate. Okay.
Well, I could potentially, not knowing the analyst, but do June 22nd and 23rd. Would you need more time thinking that you may have motions?
I think that would be appropriate. Just
I'm fine with that. You can just say, yeah.
Yeah.
Because that's kind of, just am pretty confident that another trial is coming off those days. August 4th. Oh, actually, August 4th, 5th, 6th. Any of those days?
any of those days will work.
All right, and will that give you enough time for?
That will be enough time.
Wausau Crime Lab, is that 608-266-2031?
I have 715-845-8626.
State Crime Lab, this is Ally.
Hi, this is Judge Mogan in Burnett County, and I'm calling to schedule a jury trial with lab analyst Michelle Fleckel.
All right. And what day or days were you looking at?
We could do anything. Hopefully she has a number one, any day. It'll be a 1 day, August 3rd through August 6th.
All right. Looks like she is available the 4th, 5th, and 6th as number one.
Let's do the 4th for a number one.
All right. And do you have our lab case number?
Yes, that would be DFS-CL25-07220.
And the defendant's name for this one?
Robert Teske, Teske,
And do you have the court case number?
25 CF 160.
All right. I'll go ahead and get that all scheduled for you.
All right, do you need contact info?
No, we should have you all set for that.
Excellent, thank you so much.
Of course. Bye.
Bye. Back on the record, same appearances as previously noted. The court has now called and scheduled the lab analyst for a number one on June 4th. We are, yes.
I believe that was August 4th, Your Honor.
Oh, August 4th, sorry. Why did I say June? Thank you. Because I had said June before and then didn't work. August 4th, thank you. August 4th. And now we need to set a final pre-trial. July 9th. Mr. Felisky, you have your pick anywhere from 9 until 11:45 for a status conference block.
Anytime that day will work, Your Honor.
See you bright and early at 9.
There we go.
9 a.m. So 9 a.m. on July 9th for a final pretrial, and August 4th is the trial date. Okay, Mr. Teske?
Yep.
The
Thank you.
final pretrial, I don't believe you've been in front of me for a trial or anything of that nature. So I will let you know, the final pretrial to me means it's the drop dead date, meaning that no agreement can be reached between the state and the defense beyond that date, unless the state dismisses counts outright or you plead to both of those charges. All right. But a lot can happen from now until then. Your attorney is going to be looking at motions to file and all of those things. I'm not going to set any of those dates. You're going to look at all the discovery and make your filings and do your things. A scheduling order will be provided, Mr. Teske, with important dates. And so your attorney will share those with you. But otherwise, trial would be August 4th, be here at 8:30 or earlier if Mr. Felisky wants you to. I will see you at 9 o'clock on July 9th. Probably we'll have other dates in between, but keep in contact with Mr. Felisky. Okay.
Will do.
All right. Thank you. We are adjourned.
This status conference followed a denied suppression motion for Robert Teske. The defense requested a jury trial, which required coordinating with the Wausau Crime Lab. In a proactive move, the judge called the lab analyst directly from the courtroom to confirm availability. This resulted in a firm trial date set for August 4th. The judge emphasized that the final pre-trial on July 9th would serve as the drop-dead date, meaning no plea deals would be accepted after that point unless the state dismissed charges. This case highlights the logistical precision required for forensic testimony in criminal trials.